You in just a few minutes. And now he's here. Okay. Good morning.
Morning,
Your name is?
I'm attorney Bruce Leach here. I'm here in Schisler.
Okay, got it. All right. Good morning, Mr. Odatala.
Good morning, Your Honor. How are you doing today?
I am good. So I have your client. So this is in the matter of the people of the state of Michigan versus Marcus Monroe, file number 22-20886 FC. I have Odatala appearing on behalf of Mr. Monroe. And this is Mr. Hartman's case. So Douglas Hartman appearing on behalf of the people. This is the date and time set for pre-trial. Mr. Odatala, how would you like to proceed today?
Your Honor, we have reached an agreement with the prosecution, and we have would like to plea in this matter.
Would someone like to place the plea agreement on the record?
Mr. Hartman, if you would like to set that out, we'd appreciate it, sir.
Sure, I can do that. This is my understanding, Your Honor. We'll move to add a count, I believe, a count 5 to the information, and the count 5 will be for felonious assault. Mr. Monroe will enter a guilty plea to that particular charge. The other counts would be dismissed as sentencing. He would have an obligation to testify truthfully in the upcoming trial against co-participants, Schisler, Tyndall, and William Dillard, if that becomes necessary. He will set up a time for an officer to come over and take a statement from him between now and the time of the trial. He's expected to give a full and honest and complete statement at that point in time. He will give a summary of that statement on the record today as a part of his plea. We've agreed that the sentencing in this matter will be within guidelines. He will get full credit for the time he's been in jail. He's been in jail for, I believe, the better part of a year. Is that correct, Mr. Odatala?
That's correct.
And the resolution of this case does not, at this point in time, act as a resolution in any way of his other pending case, which is set for trial at the end of July in this court. We're still working on trying to resolve that case, and this does not affect that at this point. I think that covers it.
All right, Mr. Odatala, is that a correct summary of the plea as you understand it?
Yes, Your Honor.
All right, so Mr. Monroe, you want to raise your right hand for me? Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
All right, sir, can you state your full name for the record?
Marcus DeAndre Monroe.
Okay, so Mr. Monroe, you've heard the statement of your attorney and the prosecuting attorney. Is it your intention to plead guilty to count 5, felonious assault, which carries a maximum penalty of up to 4 years in prison? But there is a Gilbert agreement that you would be sentenced within the guidelines. You would receive credit for all the time you've served, and you must testify against your co-defendant. So is it your intention to plead guilty to that charge?
Yes, ma'am.
All right. Are you satisfied with Mr. Odatala and the advice that he has given you?
Yes.
Okay. Neither, other than that agreement, neither the prosecutor, the defendant, nor anyone on the defendant's behalf has discussed any other possible sentence with the court. Is that correct, Mr. Hartman?
Yes, Your Honor.
Mr. Odatala?
Yes, Your Honor.
And Mr. Monroe, is that correct as far as you're aware?
Yeah.
If a guilty plea is accepted, there will be no trial. This means that you will be giving up rights you would have had at trial. I'm going to explain those rights to you now to make sure that you understand them. You have a right to a speedy public trial by jury. You may ask for a non-jury trial, and if the prosecutor and court agree, you can have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you are guilty, and you do not have to prove anything. You have the right to be present at trial and have witnesses against you appear at your trial and to ask those witnesses questions. You have the right to have the court order any witnesses you have for your defense to appear at the trial. You have the right to remain silent during your trial and not to have your silence used against you. However, you also have the right to testify at your trial if you want to testify. Do you understand that if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at trial? Do you understand that, Mr. Monroe?
Yes, ma'am.
Do you understand that any appeal from the conviction and sentence pursuant to the plea would be by application for leave to appeal and not by right? Do you understand that?
Yes, ma'am.
If you are not a citizen of the United States of America, a conviction of a crime may result in deportation, exclusion from admission to the United States of America, or a denial of naturalization. Do you have any questions about the rights that I've given to you?
No.
All right, so Mr. Monroe, how do you wish to plead to the charge that on or about June 26th of 2021 in Madison Township in the county of Lenawee that you did commit the offense of felonious assault?
Guilty.
Okay. Has anyone made any threats or promises to you to induce you to plead guilty to this charge?
No.
Do you understand that if I accept this plea, you will be giving up any and all claims that your plea is given as a result of promises or threats that were not disclosed to the court on the record during this hearing, or that it was not your own choice to enter the plea? Do you understand that, Mr. Monroe?
Yes.
Is the prosecutor or defense counsel aware of any promises or threats or inducements other than the plea bargain to induce the defendant to plead guilty? Mr. Hartman?
No, Your Honor.
Mr. Otatella?
No, Your Honor.
All right, Mr. Monroe, has your attorney promised you any particular sentence or estimated what your sentence will be other than the agreement that was placed on the record?
No.
Okay, is it your own choice to plead guilty?
Yeah.
All right, so I don't know, Mr. Otatella or Mr. Hartman, because of the nature of the plea, if either of you wish to voir dire or place factual basis on the record, or do you want me to?
I'd be happy with having Mr. Otatella place that, ask those questions on the record, and I'll happily help him at any point if he needs help.
Okay,
All right, Mr. Monroe, on the date in question, did you have a, let's see how we want to proceed with that.
well, let me, Mr. Monroe, let's start with this. On June 26th of 2021, were you in Madison Township in the county of Lenawee?
Yes.
Okay, then go ahead, Mr. Otatella.
Okay. Did you have a weapon in your possession on that date, Mr. Monroe?
Yes.
And did you point said weapon at the victim on that date?
Yes.
And did you place the victim in a fear on that date?
Yes.
Okay. Your Honor, I believe we've established the factual basis.
Mr. Hartman?
Okay, so let's amplify that a bit, Mr. Otatella. Mr. Monroe, I'll ask you a few questions. That's okay. Is that all right?
Yes, sir.
Okay. So what type of weapon did you have?
380 handgun.
And was that your weapon?
It was mine at the time, yeah.
Okay. Where did this event occur at?
Madison Township, on Cloverdale Street.
Whose house were you at? Were you at a party that night?
Yeah.
Whose house were you at?
Diamond Russell.
Okay.
What was the name again? Mr. Hartman, we didn't catch that name.
Diamond Russell.
What's first name?
Diamond.
Diamond.
Spell that?
Diamond.
Diamond, okay, got it. All right, never mind.
And about what time did this incident occur, Mr. Monroe, if you remember?
If I remember correctly, probably around midnight, going on midnight.
And tell us what happened.
Car came approaching down the street. Slow pace, windows down. I seen two masked men, two men with ski masks. As they got closer, I seen the driver wave a gun. I opened fire on them. They drove off. I turned around. I see my co-defendant, William Dillard, wrestling with a gun with another individual that I couldn't make out. Will Dillard had got the gun from him. The car went down the street, made a U-turn. At that point, I took cover again behind the car. When they came back, they opened fire on me. I returned fire again, as well as my co-defendant. And that's what happened.
You said you saw Mr. Dillard wrestling with a gun?
Yes.
What does that mean, wrestling with a gun?
Like he was trying to take the gun from another individual.
All right, did you see Mr. Dillard fire the weapon?
I didn't see him visually, but he was next to me and I heard the shot, so I assumed that it was him firing.
How close was he to you?
I say a couple feet, like side by side. I was kind of like in front of him though.
Was there anybody else next to him at that point in time that you were aware of?
No, there was a crowd more of it in the back, but they were just other friends I knew, and they were basically taking cover from the shooting.
So who do you think he was wrestling with a gun with?
There was a couple individuals out of town that I don't, you know what I'm saying, that I didn't really know personally. I don't even think that he knew him personally. And he was just wrestling. It was like a light-skinned figure. He was just wrestling with the gun. He had finally got it from him.
So your statement was that you saw someone with the windows down and had a gun in his possession.
Yes.
You said he was wearing a mask?
Yeah.
He did not fire at you at that point?
He did not fire first.
You fired at him initially?
Yes.
Did he point the gun at you?
He just waved it in the air, so it was visible for me to see.
And you, how many shots did you fire at the vehicle at that point in time?
At that time, probably like 2 shots.
And how about the person who was right next to you, who you assumed to be William Dillard?
He didn't fire the first round when the car came the first time. He didn't fire.
When did he fire?
He fired when the car came back and returned fire on me.
Where was Skysh and Tyndall throughout this?
Skysh and Tyndall was in the house the whole time.
He never came out?
No,
Not even at the end?
no, I went in the house and seen him on the ground. Went in the house to check on my baby mother. My baby mother was at the residence at the time. When I went in the house, Skysh and Tyndall was on the ground.
When did William Dillard fire a weapon?
After the car came the second time.
Before or after that car shot?
After the car shot at me.
So you're saying that Mr. Dillard fired in self-defense,
Yeah.
but you're not saying that you fired in self-defense.
No, I mean, I was fearing my life when I seen 2 masked men coming down the street waving a gun at me, but.
Okay, so you are saying you fired in self-defense.
Yeah, I was in fear of my life.
Okay, Your Honor, we're going to reject the plea at this point in time. Thank you.
Yeah.
So, Mr. Odetella, we have a couple options. You can have a breakout room with your client and take whatever time you need, or not, if you want to try again.
Yes, if we can, Your Honor.
Okay, so Mr. Hartman, do you have a few minutes to stick around?
I do.
All right, so Mr. Odetella, I'm gonna put you in a breakout room with Mr. Monroe. So, Mr. Monroe, you may go automatically, or you may have to use the mouse to click on Zoom. There you go. All right, Mr. Fleming, were you able to have communication with Mr. Sneed?
I was, Your Honor, and as far as the alcohol tether for Mr. Winhoven goes, we would stipulate to removal of that alcohol tether.
All right, so Ms. Adams, we're going to be modifying the bond to remove the alcohol tether Do we need to send that to Mr. Churchill to have his client sign?
It's up to you, Judge. I mean, sometimes we just have your signature on there. It's fine.
Okay, all right. So Mr. Churchill, we will modify that, and our next pretrial will be August 2nd at 8:30 in the morning. Mr. Churchill, where did your client get the tether placed on? Like, where did he go to have that done, or was it done at the jail?
At the Courthouse Commons building.
Okay, so, Mr. Churchill, Miss Adams, well, if we could email to Mr. Churchill, copy the paperwork, he could probably go today and get that removed, okay?
Okay, very well. Thank you, Your Honor. Thank you, Mr.
All right.
Fleming.
Thank you,
Yep.
Mr.
We'll
Okay,
see
have a
that
good day, Judge.
August 2nd at 8:30. Thank you.
Yep, have a good day.
You too.
Okay.
Okay. And is your attorney out in the hall?
Yes, Your Honor.
Grab him. Or when he's ready. Mr. Mawad, you have. Canela.
Judge, there's two, Canela and Lowe. Canela and Lowe.
All right, and let's see. What is the AG? So I have Mr. Lowe. And Ms. Van Duzen, do you need to speak to Taylor Tario?
No, Your Honor.
Okay. Profile. All right, this is, what are you doing today with Ms. Tario, Ms. Van Duzen?
You're setting up for a trial, Your Honor.
Okay. All right, Ms. Tario, can you hear me?
Yeah, I can now.
All right, this is in the matter of the people of the state of Michigan versus Taylor Ray Tario, file number 21-20257FH. I have Christopher Fleming appearing on behalf of the people, and I have Dawn Van Duzen appearing on behalf of Ms. Tario. This is the date and time set for pre-trial in this matter. Ms. Van Duzen, you said you were going to be asking for another pre-trial. How far out?
Not a pretrial, Your Honor, trial, jury trial.
Oh, jury trial. Okay, how long do you think you will need for trial?
Just one day.
Just one day. Let me pull this out. Okay, let's see, this is an older file, so I can set it for September 25 at
Your Honor, I'm on vacation that day.
Miss Mir is actually out of the office that day as well.
okay, October 17.
That works, Your Honor.
All right, let's set
Agreed.
trial for one day.
That works as
October
well.
20. Good. All right, October 17 of 2023 at 9 a.m. And I'm going to require that all motions be filed and heard by October 4, 23. I will also require jury instructions and voir dire questions be provided that day. And I will set a final pretrial on October 4 of 23 at 8:30 in the morning. So I have filled out a scheduling order and you will get a copy of that out to both of you. Anything else we need to address?
Not in this case, Your Honor.
None for the people. Thank you, Judge.
Your Honor,
All right, thank you.
Your Honor, I'll be handling Mr. Malaro's cases, but I have, he had an emergency that just came up a few minutes ago.
No, it's okay. Do you have to go down to Judge Olsaver?
Nope, Ms. Underwood's handling those ones. So I will do the ones in your court, but I need a few minutes just to know what I'm doing in those cases.
Okay, okay, all right. All right, Mr. Lowe, can you hear me?
Yes, ma'am. Yes, Your Honor.
All right, this is in the matter of the people of the state of Michigan versus Cody Joseph Lowe. We have two files. Mr. Mawad, are you on both of them?
No, Judge, I am on the older case.
Okay. Yep, you're right.
But
All right, so I have Elias Mawad appearing on file number 21-20527 FC, and I have Dawn Van Dusen appearing on behalf of Mr. Malaro on file number 23-21347 FH. And is that you, Mr. Hartman?
I can handle this. I think it's actually Mr. Glazier's case for the other case that Mr. doesn't have, but Don can step in certainly today.
Okay, I'm sorry, I didn't. All right. So, and Mr. Hartman appearing on behalf of the people. So, Mr. Mawad and Ms. Van Dusen, how are we proceeding today?
Don, my understanding, I talked to Mr. Hartung yesterday, is that on your case, we're going to need, on your case, another 60 days. Mr. Hartung, is that about right? Is that what you'd like to get?
45 to 60 days is what I indicated to you, in that range.
Okay. Okay. If that's
For
fine
another
with me,
pre-trial?
Don, if that's okay.
Yes.
Another pretrial, yes.
That's correct, Your Honor.
All right, so I will set another pretrial available August 30th at 8:30.
Yes, Your Honor.
That'll be fine.
Okay, so I will set both of these for another pretrial on August 30th at 8:30 in the morning. Mr. Mawad, if you can do the stiffen order on your file, and Ms. Van Dusen, if you can do the stiffen order on Mr. Glazier's file. So we will see you back on those days. Thank you. So you're all set, Mr. Lowe, okay?
Okay, thank you.
Thank you. All right, so then, Mr. Mawad, you have Peter Canela.
Correct, Judge.
Let me see if this is Peter Canela. All right, I have a gentleman looks wearing a blue sweatshirt. What is your name, please?
Peter Canela.
All right, Mr. Mawad, I have Mr. Canela. Let me grab his file. All right, this is in the matter of the people of the state of Michigan versus Peter Alex Canela, file number 23-21299FH. I have Elias Mawad appearing on behalf of Mr. Canela, and I have Christopher Fleming appearing on behalf of the people. This is the date and time set for a pre-trial. So, Mr. Mawad, how would you like to proceed today?
Your Honor, I did talk to Mr. Fleming yesterday. We're monitoring his mental health. Mr. Fleming, how long would you like to get a final, maybe look at this to decide what you wanted to do on the case? What do you think? 30 more days or?
Yeah, about 30 days sounds more accurate. I put in a call with CMH, Your Honor, and I haven't heard back from his case manager yet, but hopefully I hear back soon here.
Okay. Would August 2nd be all right, Mr. Mawad?
Judge, I start about a week-long CSC trial in Wayne County on the 29th. If we could go into
August 9?
Yeah, I think that should be okay. You know, you never know, but your court's always great. If there's a problem, I can call you guys. That's fine.
All right. So, Mr. Canela, we're going to set another pre-trial for August 9th at 8:30 in the morning. And Mr. Mawad, if your office can do the stiffen order to adjourn, Mr. Fleming, can you sign your name with permission?
Absolutely, Judge.
That's fine.
All right. Thank you. Thank you, Mr. Canela. Thank you, Mr. Mawad.
Thank you, Judge.
Thank you.
Thanks, Eli.
All right, Mr. Canela, I'm gonna go ahead and disconnect you. All right, so Mr. Odetella,
Hey, Your Honor, back on the,
back on the matter of the people of the state of Michigan versus Marcus Monroe, 22-20886 FC. So, Mr. Odetella, how would you like to proceed now?
Your Honor, my client would like to plea. He's a bit nervous there. I think we went from factual basis into the testimony. So he wasn't sure what was going on, but he'd like to proceed with the plea if Mr. Hartman will still take that in this matter.
If he's going to testify as we discussed, that's fine, but I'll ask you, Mr. Odetella, why don't you ask him the questions for this purpose of the plea, including what his anticipated testimony would be at trial before we have an officer go in and interview him.
Yes. So, you want me to get the factual basis as well on this?
Yes, please.
Okay. So, Mr. Monroe, on the date and time that was placed on the record in Madison Heights,
Madison Township.
I'm sorry, in Madison, sorry, in Madison Township, did you have a weapon in your possession?
Yes,
What was that weapon?
380 handgun.
And was it in your name?
No,
Okay. You had it in your possession though, right?
yes,
Okay. Did you point it at the victim?
yes.
Okay. And what did you do with that weapon?
I fired at the victim.
Okay. Was that victim placed in a state of fear?
Yes,
Okay. And let's see. Your Honor, what was the address on that? I'm sorry.
Well, it would be, all right, so Mr. Monroe, as you said, on June 26th, you were in Madison Township in the county of Lenawee, is that correct?
yes, ma'am.
And you were at a Diamond's home, is that correct, her house?
Yeah.
Yes,
And you would agree that that house was in Madison Township?
yes.
Okay, Mr. Hartong, anything else?
Yes, Mr. Odetella is going to need to solicit the anticipated testimony related to the co-defendants, Your Honor.
Okay. Mr. Monroe, who was with you on that day?
William Dillard.
Okay. And Mr. Monroe, why don't you tell us what happened with you and Mr. Dillard on that day?
We fired at the victims, alleged victims.
Okay. So when you said you fired at the alleged victims, when you said you fired at the alleged victims, who fired at the alleged victims? Was it you and Mr. Dillard?
Yes,
Okay. So earlier you said that there was a wrestling of the gun. Was there any wrestling of the gun?
no,
Okay. And when you said that there was a wrestling of the gun, did that come from a nervousness that we discussed because it's your first time giving any testimony?
yes,
Okay. All right. I just wanted to make that clear, Your Honor. And you saw Mr. Dillard firing?
yes,
Okay.
And he fired that weapon towards the vehicle?
yes,
Okay.
And just to make clear on this, just because my client doesn't have any information, you said, where was Mr. Tyndall during this?
he was inside the home.
Okay. Yeah. And that's your testimony at this time?
Yes,
Mr. Hartong, any follow-up?
Couple quick questions, Mr. Monroe. Make sure I understand the sequence here. You're saying the time they drove by, the vehicle drove by, when you indicated that you fired at the vehicle, saying that Mr. Dillard also fired at the vehicle at that time.
No, Mr. Gillis still didn't fire to the second time.
Okay. I guess I misunderstood what you said before. You said indicated that there was a firing that occurred to your side.
Yeah, but that was the second time the car came around, but I don't know if he fired first or if the car fired first at us. But I'm saying I fired at the vehicle first. When the car came back, I don't know if he fired first or if the vehicle fired first. It was you know what I'm saying? But he was side by side to me at that point in time.
Do you know who was in the vehicle?
I mean, I knew that just from text messages and talk before the shooting happened that it was Cruz Silva and Terrell Love, but Cruz Silva did have a mask on and I couldn't see Terrell Love in the passenger seat.
You knew they were coming over.
Right.
From previous Snapchat or other types of messaging to you or to the crowd or to the people at the party, right?
That's correct.
And where were you at when you received that information?
I was outside of the house.
Okay, how far away from the road were you when this shooting occurred?
Probably just a couple of feet. I wasn't far. There was a tree right next to the road, and I was right behind the tree when it first rolled down.
And where was Mr. Dillard?
Mr. Dillard was behind me at that point. Mr. Dillard was the one that notified me that the car was coming down the street.
Okay, all right. Prior to walking out by the roadside, did you have the gun with you?
Yeah, I had the gun on my person all night.
What kind of gun did Mr. Dillard have?
He had a .380 also.
Okay. Did Mr. Tyndall ever have a weapon in his hand that evening that you saw?
No.
Okay. Thank you, Your Honor.
All right, are you satisfied, Mr. Hartman?
Yes.
All right, has the court complied? Has the court complied with the MCR 6.302 B, C, and D? Mr. Hartman?
Yes, Your Honor.
Mr. Otatala?
Yes, Your Honor. Thank you.
All right, I accept the plea. It has been given understandably, voluntarily, and accurately. The defendant has full knowledge of his rights. He does have competent counsel. Other than the Gilbert agreement that was placed on the record, this court has made no agreement regarding the possibility of a plea or possible sentence in this case. The prosecutor, the defense attorney, the defendant, or anyone acting in the interest of either of them. I'm going to refer this matter to the probation department for a pre-sentence investigation. So, Mr. Otatala and Mr. Hartman, I'm going to give it my standard sentencing date. Obviously, if we need to move the sentencing date, that's fine, but it would make sure that the PSI is done in a timely manner. So I'm going to set this for sentencing on. Mr. Otatala, are you available August 3rd for sentencing at 8:15, and it can be done via Zoom if your client has no objection.
8:15 is perfect, Your Honor.
All right, so I'm going to set this for August 3rd at 8:15 for sentencing. So, Mr. Monroe, someone from the Michigan Department of Corrections is going to meet with you, and they're going to give you a packet to fill out, and then they're going to give you sit down and meet with you, and they're going to ask questions. Be truthful with them about your background. Be truthful about the events that occurred. They'll prepare a report. We will send that to both Mr. Hartman and Mr. Otatala. Mr. Otatala will review that with you before sentencing, and then we will see back on that day. Now, Mr. Monroe, you do have a right to be present in person for sentencing, but you can do it via Zoom if you would like. Do you care whether, or do you object to doing it via Zoom, or do you wish to be in person?
I have no problem either or.
Okay, so we'll do it Zoom. All right, anything else, Mr. Hartman or Mr. Otatala?
Not at this time.
Nothing further, Your Honor. Thank you.
All right, thank you, Mr. Otatala. Thank you, Mr. Hartman, and thank you, Mr. Monroe. You're all set.
Thank you.
Miss Adams, if I could get,
Small good.
let's see. Anybody? It looks like Don's got them all. So. Oh, there's Mr. Leach, okay. Mr. Barton, can you hear me?
Yes.
All right, we'll be with you in just a moment, all right?
Okay, thank you, ma'am.
All right, Mr. Leach, why don't you and your client come up to the podium?
Yeah.
And Mr. Schisler there. All right, this is in the matter of the people of the state of Michigan versus Aaron Eugene Schisler, file number 22-20739 FH. I have Bruce Leach, P75056, appearing on behalf of the defendant, and then Christopher Fleming appearing on behalf of the people. So obviously, your new counsel, we originally had been set for trial on June 6th, but it looks like that was set aside because you came on the case.
Yes,
So I have the plea offer on this file is plead to count 1, felonious assault, and dismiss 2 and 3. So Mr. Leach, how do you wish to proceed on behalf of Mr. Schisler?
Well, Your Honor, I had driven down here from Flint in person in hopes to have a conversation with Mr. Fleming this morning regarding this matter.
But if you have your phone and you'd like to zoom in on your phone, I can let you go back in the jury room.
Okay, that would be fine. I would like to have a chance to talk to him.
Okay, yeah, I have some, I have Phoebe Muir now, so Mr. Fleming, I can let her in and, so you can either go in the hall or you can go in my jury room.
I'll go in the jury room.
All right, so do you have my Zoom number?
I'm ready.
You do?
No, I don't.
I'm gonna write it down for you.
Thank you.
So Mr. Schisler, you can just have a seat. And my bailiff will hand you my Zoom number and let you in back.
Is
And
that
then,
passcode required as well, Your Honor?
I'm sorry.
Is there a passcode that's required? No? No.
So when you're done, you can just go down the hallway and out the door there.
Thank you very much, ma'am.
You're welcome. All right, so, as soon as he logs in, Mr. Fleming. All right, Ms. Van Duzen, I do have Mr. Barton. Oh, actually, are you Rhonda Underwood too?
No, Your Honor.
Okay, sorry.
Your Honor,
She's
Mr. Barton's
actually
one of my clients.
Okay, she's actually Zooming with the judge next door and then she'll be here, so, all right. So, Mr. Leach, I am going to put you and, Mr. Fleming into a breakout room. So, yes. All right, go ahead and join that breakout room.
Thank you, Your Honor.
You're welcome. All right, this is in the matter of the people of the state of Michigan versus Blake Anthony William Barton, file number 23-21272 FH. I have Matthew Murphy appearing. You said this is yours, right, Mr. Murphy?
Yes, Your Honor.
Appearing on behalf of Mr. Barton. Mr. Barton is appearing via Zoom. And I have Alexander Bayonetto appearing on behalf of the people. So this is a first pre-trial. I do show the plea offer was plead as charged to count 1. Yes, count 2, and the second offense would be dismissed. So, Mr. Murphy, how do you wish to proceed on behalf of your client?
Your Honor, at this time, I'm asking if we could do another pretrial. I have some more research I need to do in regards to if I'm going to file a motion in the case. And I also am contemplating needing an expert, so I have to run that past my boss. I haven't talked to Ms. Van Duzen about that. So if Mr. Bayonetto wouldn't object, I would ask for just another pretrial before we decide to set trial or not.
All right, my next available pretrial is August 2nd. Are you available that day?
That worked for the defense, Your Honor.
All right, so we'll set this for August 2nd at 8:30. Mr. Murphy, can you do this in order to adjourn? And Mr. Bayonetto, can you sign your name with permission?
Yes, Your Honor.
Yes, Your Honor. Thank you.
All right, very good. Thank you. Mr. Barton, you're all set.
Awesome. Thank you guys very much. Thank you, Your Honor.
Thank you, Mr. Barton. Have a good day. Thank you.
You too.
All right, and who, so, oh. And who do I have from the jail?
Michael Spence.
All right, Mr. Spence, let me find your file. All right, your attorney is actually Rhonda Underwood. So Ms. Van Duzen, you said Ms. Underwood's gonna be coming in, right?
That's correct, Your Honor.
All right, Mr. Spence, I apologize. Well, Ms. Underwood is next door in front of Judge Olsaver. So would it be possible for you to just tell them that I'm gonna take you at the end of my call and if they could send the next person?
Okay, yes.
All right, thank you. I apologize.
No problem. Thank you.
Thank you. Mr. Glazier.
Yes, Your Honor.
Oh, no, just hi.
Oh, hi.
I only had you for Cody Lowe today. Is that correct?
I think that's it, yeah.
So we set that out for pre-trial on August 30th at 8:30 in the morning.
Okay. Was Cody there? Did he get the notice?
Well, you got to do the stip in order, but he was on the record, so I did notify him on the record
Okay, adjourned to August 30th.
at 8:30. Yes, sir.
Hey, John, I handled that for you.
Okay, all right, thanks. That's all I have. Thank you, Your Honor.
Thank you. All right, Miss, let's see, Miss Van Duzen, how about Reginald Allen? He's not in jail yet because he's not here either, so. In the matter of the people of the state of Michigan versus Reginald Lee Allen, file number 22-20967 FH. I have Don Van Duzen appearing on behalf of Mr. Allen, and I have BB Neer appearing on behalf of the people. I do have a stip in order that was prepared, adjourning it from May 31 to today. He is not in my, who do I have joining me from the jail?
Tim Palm.
Okay, but Mr. Allen is not present today and I do not show him on my jail list. So Ms. Van Duzen. You're muted, Ms. Van Duzen.
Looks like our office has tried to contact him and his phone is no longer working.
All right, well,
And,
I will.
and Judge, I do want to point out too, on the 31st, he didn't appear and we adjourned it instead of issuing a bench warrant or show cause. So I would just ask that a bench warrant be issued today.
Okay. All right, so I will issue a bench warrant for his arrest and I will set bond at 150,000 cash. Right. Okay, Mr. Leach, you
Yes,
set?
Yes, ma'am, you are.
All right, why don't you guys step back up? So we are back on the record with Mr. Schisler. Let me see if Mr. Post is
Thank you.
coming. Mr. Coast, what case are you coming in on?
That you don't necessarily need to be here for that, it will just be pre-trial, if the trial gets set.
Darren Coast?
Get notice of that, you need to be pre-trial.
All right, so Mr. Leach, how do you wish to proceed on behalf of Mr. Schisler?
Thank you, Your Honor, for allowing us some time to have a meaningful pretrial discussion this morning. We would ask that another pretrial date be set for a final pretrial in approximately a month or so. At that time, we do have a possible resolution pending. So that would allow Mr. Fleming and I both to enough time to pursue that negotiations.
All right, so my next August 2nd, are you available August 2nd at 8:30? It could be via Zoom too.
August 2nd works, Your Honor, yes.
Okay. So I will set this for another pretrial. Miss Adams, Mr. Schisler is present, so can I get that notice of hearing?
Okay.
So we'll set it for August 2nd at 8:30 in the morning. Typically, we do stiffen orders to adjourn the party. Defense counsel will prepare them, but because he's here in person, I need to hand him notice of hearing. So
Thank you, Your
you
Honor.
won't have to do it on this one. And that can be via Zoom too, for both of you if you'd like.
Thank
We're
you.
open for people to come in, but we also,
Well, given the importance of this matter, it was important to me to come down and be here in person today.
so, all right, just have a seat. We'll get you notice, okay?
Thank you, Your Honor.
You're welcome. All right. All right, who do I have at the jail again?
Chandler Fountain.
All right, Miss Van Duzen, it's Chad LaFontaine, right?
Yes.
I get bad echo from that room. It's not your fault. I'm sorry. All right, this is in the matter of the people of the state of Michigan versus Chad William LaFontaine. We have multiple files, 23-21288FH, 23-21289FH, 23-21290FH, and 23-21291FH. I have Dawn Van Duzen appearing for Mr. Malaro today, and I have Christopher Fleming appearing on behalf of the people. So, Ms. Van Duzen, how do you wish to proceed today with Mr. LaFontaine?
Your Honor, this hospital, I'd ask that we set this to later this morning. I need time to talk to Mr. Fleming on this matter.
I can't hear you, Ms. Van Duzen. I mean, just speak up a little bit.
Can you hear me now?
A little bit better, yeah.
Can we set this for later this afternoon or this morning? Due to the fact there could be a possible resolution for a plea on all files.
Okay, do you need to talk to somebody?
Mr. Fleming and I are corresponding via text, but he is still looking at them all to get a global resolution.
Okay, all right. Is that all right with you, Mr. Fleming?
Absolutely, Judge.
All right, so, sir, I appreciate, I apologize. So why don't you let the jail know that I'm gonna put you to the end of call, and if they could send in, hold on, let me see. How about if they could send any of the females?
Okay.
Actually, could you just tell them I'll take Miss Bussin?
Okay. Yes, ma'am. So does
All right,
you put you out for a minute?
Yep, they're talking, and then we'll bring you back this morning, and then you'll get to talk. Okay,
All right, thank you.
thank you. All right, Mr. Wood, Miss Underwood is down the hall, so I haven't forgotten about you. So, oh, now I got Miss Underwood. All right. All right, do you want to come up to the podium? I'll get you out of here, because you've been sitting here so patiently. Mr. Coast, who are you here on this morning?
Judge, he was coming in on LaFontaine.
Oh, okay.
Yep.
All right.
Sorry about that, Judge.
It's okay. It's kind of been set over to later in the morning. All right.
Thank you.
All right, this is in the
Yeah,
matter.
go ahead and send that over to Judge Anslone's court as soon as I.
The matter of the people of the state of Michigan versus Ahmed Abdul Karim Al Mohammed, file number 22-21166FH. I have Rhonda Underwood appearing on behalf of the defendant, and I have Alexander Bayonetto appearing on behalf of the people. Mr. Al Mohammed has been present in the courtroom. So, Ms. Underwood, how would you like to proceed with your client?
Your Honor, we do not have the transcript yet. We're waiting on that. We ordered it in April. I would imagine it would be here soon. So we would like to ask for one more pretrial, Your Honor.
Okay, so the 90 days will be up in July. So, Ms. Underwood, are you available August 2nd?
I am, Your Honor. Thank you.
All right, and Ms. Adams, could I get a notice of hearing for him? He is present. So I'll set it for another pretrial, August 2nd of 23 at 8:30 in the morning. Ms. Underwood, because he's here, I want to serve him, so we'll do the notice of hearing. And obviously, Ms. Underwood, if you get the transcript and there's a resolution, please let us know. I'd much rather take it on a day that's not a Wednesday, all right?
Thank you so much, Sean.
Judge, I'm
Thank you.
sorry.
So-
Who do we have in the courtroom?
We have Mr. Al Mohammed, and I'm setting it for pretrial August 2nd at 8:30, and he's present, so can I just get a notice of hearing for him?
Yes.
All right, you can have a seat right there, and she'll bring that to you. Thank you so much. All right, and know that you can always zoom in if you're able to.
Yeah, I'm only like 2 blocks down in.
Okay,
I'd rather just show
might as
up.
well walk, right?
Yeah.
All right, so who do I have joining me from the jail?
Marley
Thank you,
Bussing.
Ahmed.
All right, so this is in the matter of the people of the state of Michigan versus Marley Iva Bussing. We have file number 23-21394 FH and 23-21395 FH. And who's your attorney? Your attorney is today Dawn Van Dusen, appearing on behalf of Mr. Malaro, and I just need a prosecutor. This is Marley Bussing. Oh, I got 2 now, so I'm gonna go with Mr. Fleming, appearing on behalf of the people. So, Ms. Van Dusen, when you are ready.
I have this blessing on my schedule.
I don't have anything in my file, Mr. Oh, this is actually arraignment on both of these files. I'm sorry. So, Ms. Van Dusen, do you waive the reading of the felony information?
Yes, Your Honor.
All right, and has your division received a copy of the felony information, witness list, and request for discovery?
Yes, Your Honor.
And Mr. Fleming, do you know if there has been a plea offer in this file?
I don't, Judge. I don't see this up on our calendar, but I am pulling up the file now.
It was set for arraignment today.
Judge, this is my case. I just thought Mr. Fleming was handling the arraignments today. I can tell you that Ms. Bussing has a myriad of charges, and we've declined to make any sort of offer at this time. This is probably 2 of 4 or 5 pending files.
All right. Are any of them up here already?
One is awaiting arraignment in district court. Another is still pending in district court. And then I do believe she has 1 or 2 up here already, I think.
I can get those.
Or she might have already pled, so she might actually be on circuit court probation on those. But yeah, there's a lot of files.
All right, so Ms. Van Dusen, I can set this out to August 2nd, just to monitor the other files and enter a plea of not guilty on your client's behalf. So how would you like me to proceed?
Set it out, Your Honor. It looks like all the other files are closed. I think they were dismissed, in fact. But yeah, Your Honor, can we just set this for a pretrial?
Okay, so I'll set it for August 2nd at 8:30 in the morning. This is arraignment. I'll enter a plea of not guilty on behalf of Ms. Bussing, and Ms. Bussing, we'll see you back on August 2nd at 8:30 in the morning. And because it was an arraignment, my office will do the notice of hearing. All right, you're all set, Ms. Bussing. Thank you. Let's see. All right, I have a gentleman that just zoomed in on an iPhone and he's not wearing a shirt. So I assume you're just gonna pop over and put a shirt on right now for me, right?
Yes.
Okay. Because you wouldn't want all of us to show up with no shirt on. So, all right. So, sir, what is your name, please?
Reginald Allen.
Oh, Mr. Allen. Okay. So, we are back on the record in the matter of the people of the state of Michigan versus Reginald Allen, file number 22-20967FH. Mr. Allen, I thank you for showing up. We had called it earlier and I issued a bench warrant, but I will quash that bench warrant because you did appear. So, Mr. Allen, your attorney is Rhonda Underwood. No, it isn't. It's Sam Milaro, and I have Dawn Van Dusen here today for Mr. Milaro. So, Mr. Allen, hold on one second. So, Ms. Van Dusen, how would you like to proceed with Mr. Allen today?
Your Honor, can I ask for a second pretrial for a couple of weeks? Any time to be able to talk to Mr. Allen.
So the thing I wanted to point out is on the 31st when we were here, obviously Mr. Allen wasn't here, but when Mr. Milaro and I had, and I believe he spoke to Mr. Allen about this plea to a disorderly with fines and costs. I don't know if that's something he can do today or if we do need to put it out, but I assume if he's here, we can get it done.
So, Mr. Allen, you have a bunch of charges. I don't even have your file anymore. I think maybe I don't. Hold on. Ms. Adams, if I could get his file back. So, oh, look, she's so fast. All right, so Mr. Allen, your information charges you with arson, preparation to burn a dwelling, which is a 10-year felony, attempted home invasion, first degree, which is a 5-year felony, and malicious destruction of a building, which is a 1-year misdemeanor. So all of those carry potentially prison term, they carry fines, costs, and probation. Your attorney worked out with Ms. Meir to plead to a 93-day disorderly with just fines and costs. So that would be a total of, hold on a second. Let me tell you what that would be. That would be a total of $225 and fines and costs, no probation. So do you need a moment to talk to your attorney to see if that's something you want to do, or would you like to do that?
I think I would like to do that.
Okay. Do you need to talk to your attorney or you just want to proceed?
We can proceed.
And Judge, I did do an amended information with that. Do you need me to send that along again, or do you have that? It was filed back for the 31st date, so you should have it, hopefully.
Well, one would think, right?
So would this lift the no contact order between me and my fiance?
Yes.
Yes.
Okay.
I have it, Ms. Meir. All right, so Mr. Allen.
Huh?
Why don't you raise your right hand so I can see it?
Okay.
All right, do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth?
I do.
All right, so can you state your full name for the record?
Reginald Lee Allen.
All right, now you can put your hand down. So, Mr. Allen, you heard the statement of the prosecutor. Is it your intention today to plead guilty to count 4 disorderly person with a Killebrew agreement that you would pay fines and costs with no probation?
Yes.
All right. Do you are you satisfied with your attorney and the advice that he gave you and that Ms. Van Dusen is appearing on his behalf today? Are you satisfied with that? Okay. Now, do you understand there would be no jail term because it would just be fines and costs, no probation?
Yes.
All right. Now, if a guilty plea is accepted, Mr. Allen, that means there will be no trial. This means that you'll be giving up rights you would have had at trial. I'm going to explain those rights to you now to make sure that you understand them. You have a right to a speedy public trial by jury. You may ask for a non-jury trial, and if the prosecutor and court agree, you can have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you are guilty, and you do not have to prove anything. You have the right to be present at trial, have witnesses against you appear at your trial and to ask those witnesses questions. You have the right to have the court order any witnesses you have for your defense to appear at the trial. You have the right to remain silent during your trial and not to have your silence used against you. However, you also have the right to testify at your trial if you want to testify. Do you understand that if your plea is accepted, you will be giving up the right to appeal issues that would otherwise be appealable if you were convicted at trial? Do you understand that, Mr. Allen?
Yes.
Do you understand that any appeal from the conviction and sentence pursuant to the plea will be by application for leave to appeal and not by right? Do you understand that?
Yes, ma'am.
If you are not a citizen of the United States of America, a conviction of a crime may result in deportation, exclusion from admission to the United States of America, or denial of naturalization. Do you have any questions about the rights that I've given to you?
No, ma'am.
All right, so Mr. Allen, how do you wish to plead to the charge that on or about June 13 of 2022 in the village of Blissfield in the county of Lenawee that you did commit the offense of disorderly person? Guilty or not guilty?
Guilty.
All right. Has anyone made any threats or promises to you to induce you to plead guilty to this charge?
No, ma'am.
Do you understand that if I accept this plea, you will be giving up any and all claims that your plea is given as a result of promises or threats that were not disclosed to the court on the record during this hearing, or that it was not your own choice to enter the plea? Do you understand that?
Yes, ma'am.
Is the prosecutor or defense counsel aware of any promises or threats or inducements other than the plea bargain to induce the defendant to plead guilty? So, Ms. Van Duzen?
No, Your Honor.
Ms. Muir?
No, Your Honor.
All right, and all right, so it's your own choice to plead guilty, Mr. Allen?
Yes.
All right, so Mr. Allen, on June 13th of 2022, were you in the village of Blissfield in the county of Lenawee?
Yes.
Okay, and let's see, did you go to someone's house on 206 East Adrian Street?
That was my house, Your Honor.
Okay, so it was the house that you and your wife lived in, right?
Yes, Your Honor.
And would you agree you were a little upset that day?
Yes, Your Honor.
And would you agree you got a little rowdy and you broke a window?
Yes, Your Honor.
And did you start a little fire?
I didn't start a fire, but I was playing around with the lighter and the mattress, but
Say that again, because you kind of broke up for me.
excuse me.
I'm sorry, you broke up a little bit, so could you say it
No.
again?
I didn't start a fire, but I was playing around with my lighter, but I was by a mattress that we had recently had that I had outside.
Okay, so you didn't start a fire, but you could have, and someone might have thought you were going to do that, correct?
Yes.
All right, and were you loud enough that you were disruptive enough a third party could have heard you?
Yes, ma'am.
Okay, Miss Muir.
I just want to be clear, you were outside of the home, not in the home, correct?
Yes, I was outside
Okay.
my.
All right.
Yes.
People are satisfied, Your Honor.
All right, has court complied with MCR 6.302 B, C, and D? Ms. Van Duzen
Yes, Your Honor.
and Ms. Muir?
Yes, Your Honor.
I accept the plea. It has been given understandably, voluntarily, and accurately. The defendant has full knowledge of his rights. He does have competent counsel. Any objection, Ms. Van Duzen, to waiving a pre-sentence report and proceeding to sentence?
No objection, Your Honor.
Ms. Muir?
No objection.
All right, anything you'd like to say on behalf of your client, Ms. Van Duzen?
No, Your Honor.
Ms. Muir?
Just wanted to let the judge know that Miss Garrison was our original intended victim in this case. She obviously has indicated she wants this no contact to be lifted. She does not want to go forward with these charges. The house they were renting, so it was not owned by Miss Garrison. There was no restitution that was listed, and obviously Miss Garrison's insisting that Mr. Alan still lived in the home, even though at the time of the report it was not. So I just wanted the court to know the full story here and how this came about. But I do believe the disorderly charge accurately reflects at least something that Mr. Allen did that evening.
All right, Mr. Allen, anything you'd like to say on your own behalf?
When will my fines and stuff be due?
I'm gonna give you 60 days, all right?
Okay, because I'm leaving to go to California.
Okay, so, okay, well, I want you to pay it before you go to California, okay?
Okay.
All right, so it's
Nope.
sent to the court that you will pay a $75 crime victim rights fee. $50 in $50 in state costs and $100 law enforcement reimbursement. So, you know, Mr. Allen, I wish you the best of luck in California, but you know, there's an old adage that sometimes when you're really upset, just walk away until you calm down. This probably would have been a good day to do that, right? So I wish you the best of luck and I'll give you 60 days to pay that, all right?
Okay, thank you.
All right, thank you, Mr. Allen. All right, who do I have from the jail?
Tiffany Schumacher.
All right, let me grab your file. All right, this is in the matter of the people of the state of Michigan versus Tiffany Renee Schumacher, file number 23-21338 FH. I have Don Van Duzen appearing on behalf of Mr. Malaro, on behalf of Ms. Schumacher today, and I have Alexander Bayonetto appearing on behalf of the people. This is the date and time set for a pretrial conference in this matter. So is there a plea offer in this file, Mr. Bayonetto?
Your Honor, I am filling in for Ms. Arnold today. I don't know that there's been an offer made yet. I know her and Mr. Malaro have been having conversations. There is ongoing negotiations. So my understanding was that the request was going to be to set this for another pretrial today.
All right. How far would you like pretrial, Ms. Van Duzen?
30 days.
How about August 2nd?
That will work, yeah.
All right, so we will set this over to August 2nd at 8:30 in the morning for a pretrial. Ms. Van Duzen, can your office do the stip in order to adjourn, signing Mr. Bayonetto's name with his permission? You agree, Mr. Bayonetto?
Well, of course, Your Honor, yes.
All right. All right, Ms. Schumacher, you're all set. Could you have them send either Ms. Spiegel or Ms. Spiegel maybe?
Yes, ma'am.
Thank you.
Hey, they want to send people out.
Let's see if I have anybody not in jail. Ms. Murphy. Ms. Underwood. Oh, no, you waived arraignment on that one. Ms. Van Duzen, Emily Smith. So this is in the matter of the people of the state of Michigan versus Emily Ann Marie Smith, file number 23-21352 FH. This is the date time scheduled for a first pretrial in this matter. Let's see, I do have a notice of hearing, but I do not know if it went to the right address for her. No, so I have a notice of hearing that went to the address she provided to the bail bondsman, and which is different than the address on her felony information because it probably wasn't maybe changed in the system. So is she in Tecumseh or Brooklyn, Ms. Van Duzen? Do you have any notes?
I have to come.
Okay, well, it looks like our notice of hearing went to the correct address. She is not present here or in the courtroom. It is a possession of methamphetamine charge, so I guess it's not surprising she hasn't showed up. Do you have any contact with her, Ms. Van Duzen?
No, my notes don't indicate either way.
All right, so I'm gonna issue a bench warrant for her arrest, and I will set bond in the amount of 50,000 cash. All right, thank you, Ms. Van Duzen. Obviously, if you have contact with her, let us know. Ms. Spiegel, how are you?
I'm all right. How are you?
I'm all right. So this is a matter of the people of the state of Michigan versus Brianna Lynn Spiegel, file number 22-20816FH. I have, let's see who's appearing on this one today. Hold on.
It's just a, is this just a violation of probation?
Yep.
Okay.
All right, so Ms. Spiegel, this is Ms. Underwood's file. So, looks like I lost Ms. Underwood, so I just have Ms. Van Duzen. So, Ms. Spiegel, tell them that I don't have your attorney right now, and I apologize, but Ms. Van Duzen, are you ready for either Mr. Spence or Mr. LaFontaine?
So you want me to tell them that?
Hold on one second.
Oh,
Ms. Van
okay.
Duzen, are you ready on either of those?
Yes, Your Honor, if I could get a Mr. LaFontaine, and I'll need a breakout room with him.
Okay, so tell them I apologize, but your attorney left, and if I can have Mr. LaFontaine.
LaFontaine?
Yes, thank you. She'll be back in a minute.
They need LaFontaine.
Right.
All right, so Mr. LaFontaine?
Yes, ma'am.
All right, so I'm gonna open up a breakout room. And I'm gonna put you in that breakout room with Ms. Van Duzen.
Okay.
And we're, right, go ahead and use that breakout room.
Take a break?
Yeah, take a break.
So are you taking over for Milaro? Don?
See today, so,
Okay.
but yeah, can if you want.
Yeah, I mean, because you've been here for both, but you've been here for when you got me the bottom, you're already got in the case, you already know what's going on, so I'm there.
Right, so we are back, Mr. LaFontaine. All right, so this is in the matter of the people of the state of Michigan versus Chad William LaFontaine and Ms. Van Duzen. I put it again to the end of my call. Have you had enough time to speak with your client?
Yeah, sure.
All right, and how would you like to proceed today?
Mr. LaFontaine's going to plead guilty, y'all.
Okay, and let's start with file number 23-21288FH. Is he going to be pleading to any of those counts?
Yes, sure. The possession of meth, substance and rituals will be dismissed.
So it would be a controlled substance possession of methamphetamine with a 10-year.
Yes.
All right, and no stop. Okay. And then on file number 23-21289FH, what will he be doing on that file?
Plead to the RNO with the habituals dismissed. Sorry, Your Honor.
It's okay. And then on file number 23-21290FH.
To the RNO with the habituals dismissed.
Okay. And last but not least, file number 23-21291FH.
He will be, that file will be dismissed, but he will be moving to restitution in that file.
All right, and it would be restitution for the value of a cell phone, correct?
Correct.
All right. Okay. All right, is that a correct recitation of the plea, Mr. Fleming?
It is correct, Judge.
All right, so Mr. LaFontaine, want to raise your right hand, please? Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Yes.
Okay, state your full name for me again.
Chad William LaFontaine.
Okay. All right, so Mr. LaFontaine, you have heard the statement of your attorney and the prosecuting attorney. Is it your intention on file number 23-21290FH to plead guilty to count 1, police officer resisting and obstructing with no subs? And
Yes.
okay. And then on file number 22-21288FH, is it your intention to plead guilty to count 1, possession of methamphetamine with no second offense and no habitual offender?
Yes.
Okay. And then on file number 23-21289FH, is it your intention to plead guilty to police officer assaulting, resisting, obstructing with no subs?
Yes.
Okay. All right, do you understand the maximum penalty for a police officer assaulting, resisting, and obstructing can be up to 2 years in prison?
Yes, ma'am.
And that on the possession of methamphetamine charge, the maximum penalty could be up to 10 years in prison?
Yes, ma'am.
Okay, are you satisfied with your attorney and the advice that she's given you?
Yes.
And neither the prosecutor, the defendant, nor anyone on the defendant's behalf has discussed a possible sentence with the court. Is that correct, Ms. Van Duzen?
That's correct, Your Honor.
And Mr. Fleming?
Yes, Judge.
I got a letter from Steve Bovian, or David Cross, my bad, on the 16th, stating that upon my release from my misdemeanor charges, which is tomorrow, would be my release date, that I was to be in contact with him immediately to set up twice a week drug testing. Is that part of my plea agreement?
Okay, so Steve Bovian, you said?
No, David Cross, send it to me. I have the letter. I didn't bring it back in with me.
All right, so Mr. LaFontaine, hold on a second, and it is not your fault. That room has horrible audio. So scoot up a little bit. Okay, so you got a letter from district court probation.
No, from David Cost. I got a letter from him.
Oh, Darren Coates. Yes. Okay.
I got a letter from, I don't have it in possession with me. It's in my room. But he told me, he said, upon my release of my misdemeanor charges, which are my contempt of court charges, I'm supposed to get in contact with him immediately for twice a week drug testing. Is that part of my plea agreement?
No, not that I'm aware of. As of right now, you're still in jail, but if you get released from jail, yeah, you would have to contact him right away.
But he said that, but according to that, it's stating that I'm getting a PR. The way I read it is I'm getting released on tomorrow.
All right. So Mr. LaFontaine, I hate that room. I really do. So don't move your head and just kind of speak slower for me.
Okay.
Darren Coast supervises bond conditions.
Right.
Okay.
That's what he said. He said part of my bond condition.
Let me speak. Right now, you're currently incarcerated. That only comes into effect if you get out of jail.
Right.
Right now, you're not out of jail.
Right.
You might get out of jail, but I don't know as right now, there's no plea agreement with regard to you getting out of jail. Okay. Okay, so Miss Adams, could you let Mr. Coast know to log in? Let me see here, I'm looking. We got your fingerprints done. So at some point you were out of jail being monitored by Mr. Coast, right?
Yes, I was I went to rehab and I violated my bond conditions and I left rehab, but my bond was never revoked. I was on a PR bond. My bond was never revoked. So I was wanting, because I got to have some surgeries done on my kidneys. I got 2 kidney stents placed in. I knew at one time that I was in the hospital having these surgeries done. I had a kidney stent placed in the left side of my kidney and I have a double stent in at the moment. I'm still in the process of getting both of these stents removed and these kidney stones removed out of my kidney. I was just wanting to know if I could still stay on the PR bond so I could get this stuff taken care of. I am on probation downstairs in district court with Elizabeth Westgate. So I am monitored by the state as it is already for probation, and I have to drop on colors with her anyways.
Okay, so that's not part of your plea bargain, but I'm sure at some point your attorney may address it today, but whether or not you get out today is not part of your plea agreement. Is that correct, Ms. Van Dusen?
That's correct, Your Honor. I don't know
So,
what his bond is up in, or if he got a contempt. My notes do not.
he does, he has bench warrants for leaving Hope House without permission.
Okay.
So yeah, he does, but Mr. LaFontaine, that's not part of your plea agreement. We can talk about that after the plea's entered, but but it's not part of the plea agreement. All right.
Yes, ma'am.
You still want to enter the plea?
Yes.
Okay, so having said all that, neither the prosecutor, the defendant, nor anyone on the defendant's behalf has discussed a possible sentence with the court, including bond conditions. Correct, Ms. Van Dusen?
That's correct, Your Honor.
And Mr. Fleming?
Yes, Judge.
All right, so Mr. LaFontaine, if a guilty plea is accepted, there will be no trial. This means that you'll be giving up rights you would have had at trial. I'm going to explain those rights to you now to make sure that you understand them. You have a right to a speedy public trial by jury. You may ask for a non-jury trial. And if the prosecutor and court agree, you can have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you are guilty and you do not have to prove anything. You have the right to be present at trial and have witnesses against you appear at your trial and to ask those witnesses questions. You have the right to have the court order any witnesses you have for your defense to appear at the trial. You have the right to remain silent during your trial and not to have your silence used against you. However, you also have the right to testify at your trial if you want to testify. You understand that if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at trial. Do you understand that?
Yes, ma'am.
Do you understand that any appeal from the conviction and sentence pursuant to the plea will be by application for leave to appeal and not by right?
Yes,
Do you
ma'am.
understand that?
Yes.
If you are not a citizen of the United States of America, a conviction of a crime may result in deportation, exclusion from admission to the United States of America, or denial of naturalization.
Yes,
Do you have
ma'am.
any questions? Yep. Do you have any questions about the rights that I've given to you?
No, ma'am.
So, Mr. LaFontaine, let's start with file number. All right, let's start with file number 23-21288FH. How do you wish to plead to the charge? How do you wish to plead to the charge that on or about November 13 of 2022 in Madison Township in the county of Lenawee that you did commit the offense of controlled substance possession of methamphetamine? Guilty or not guilty?
Guilty.
And how do you wish to plead to the charge that on file number 23-21290FH that on or about February 10th of 2023 in the city of Adrian in the county of Lenawee that you did commit the offense of police officer assaulting, resisting, and obstructing?
Guilty.
All right. And how do you wish to plead to the charge that on or about February 10th of 2023 in Madison Township in the county of Lenawee that you did commit the offense police officer assaulting, resisting, and obstructing?
Guilty.
Okay. Has anyone made any threats or promises to you to try to induce you to plead guilty to these charges?
No, ma'am.
Do you understand that if I accept this plea, you will be giving up any and all claims that your plea is given as a result of promises or threats that were not disclosed to the court on the record during this hearing, or that it was not your own choice to enter the plea? Do you understand that?
Yes, ma'am.
Has your attorney promised you any particular sentence or estimated what your sentence will be?
No.
Is it your own choice to plead guilty to each of these spots?
Yes, ma'am.
All right, so we're gonna go back. So let's start with 23-21290FH. Mr. LaFontaine, on February 10th of 2023, were you in the city of Adrian in the county of Lenawee?
Yes, ma'am.
Now, at that time, did you come in contact with an Adrian police officer named Powers?
Yes.
All right, and so did he stop you? Were you walking? Were you driving? When did
I was
you
at the
come in
hospital.
contact? You were in the hospital. Okay,
Yes.
so you were taking, did he take you to the hospital?
No, the fire department took me to the hospital.
Who did?
The fire department,
Okay, and why did you go to the hospital? What happened?
suicide attempt.
Okay, and at some point, he came to the hospital to speak with you?
Came to the hospital to arrest me and take me to the county jail once I was released from the hospital.
Okay, and you knew he was a police officer?
Yes.
And you knew he was doing his job, taking you into
Yes.
custody? And you resisted him in some way? Did you pull your hand away from a handcuff? Did you push him?
Yes.
What did you do?
Pulled myself away.
Okay, Mr. Fleming, are you satisfied in that file?
People are satisfied, Judge.
All right, now let's move on to file number 23-21288FH. So Mr. Fleming, on this day, November 13th of 2022, were you in Madison Township in the county of Lenawee?
Yes.
And at that time, did you have in your possession methamphetamine?
Yes, ma'am.
Did you know it was methamphetamine?
Yes, ma'am.
And you possessed it because you intended to use it?
Yes, ma'am.
All right, and you had no legal right to possess that methamphetamine, is that correct?
Yes, ma'am.
Are you satisfied, Mr. Fleming?
People are satisfied, Judge.
All right, so let's move on to file number 23-21289FH. So Mr. LaFontaine, on February 10th of 2023, in Madison Township in the county of Lenawee, you at some point were in Madison Township and came in contact with an officer, Richie. Is that correct?
I was in the hospital at the same moment at that time as the same other RNO that I caught.
Okay, so we had a Madison Township police officer and an Adrian police officer with you at the hospital.
Yes.
Okay, and was the Madison Township officer in uniform? So you knew he was
Yes.
Madison Township? And was he trying to also take you into custody so that they could take you to the jail?
Yes.
Okay, and did you resist him as well by pulling away, pushing?
Yes, ma'am.
What'd you do?
Pulled away.
Okay, Mr. Fleming, are you satisfied?
People are satisfied, Judge.
Right. It was a pretty bad day, Mr. LaFontaine.
It was.
All right, has the court complied with MCR 6.302 B, C, and D? Ms. Van Duzen?
Yes, Your Honor.
Mr. Fleming?
I believe so, Your Honor.
I accept the pleas. They've been given understandably, voluntarily, and accurately. The defendant has full knowledge of his rights. He does have competent counsel. This court has made no agreement regarding the possibility of a plea or possible sentence in this case with the prosecutor, the defense attorney, the defendant, or anyone acting in the interest of either of them. I'm going to refer this matter to the probation department for a pre-sentence investigation. Ms. Van Duzen, are you available, or is Mr. Milaro available August 3rd at 8:15 for sentencing?
Yes, Your Honor.
All right, so Mr. LaFontaine, I'm going to set this for sentencing on August 3rd at 8:15 in the morning. Ms. Van Duzen, are we going to address bond before I give him the remainder of the instructions?
Yes, Your Honor, please.
All right, the record should reflect that I have Darren Coast from pretrial services present. Let's see. Hold on, let's see what is conditions, how many violations he has. Run on that file.
Judge, he was actually in treatment, left treatment. So he did plead guilty to the contempt of court for leaving treatment. And on 5/4, he received 60 days in jail.
Okay, so Miss Adams, is there anything else holding him on these files? I don't think so.
No, I was given 60 days and that was it.
Okay, so you gotta serve your, I don't know how many days in you are, but you gotta
I
serve
do
your
that tomorrow.
60 days.
Tomorrow's my out
Okay.
date.
Okay, so Mr. LaFontaine, a couple things. You will get out tomorrow.
Okay.
It's filed, from my understanding. Mr. Coast sent you a letter, so you need to contact him tomorrow morning.
Okay.
And he's gonna set up drug testing and whatever else he feels you need at this time. So if you don't comply with that, I'll issue a bench warrant again and you'll stay in jail till sentencing or even longer. Do you understand?
Yes, ma'am.
So what you do now until sentencing will determine what your sentence will be. I can send you to prison. I can give you credit for time served. I can give you a jail term. So how well you do with Mr. Coast in terms of testing and being compliant and trying to make those changes in your life will dictate what your sentence will be. Do you get that?
Yes, ma'am. Well, trust me, when I get out and I'm gonna be on my square. And Darren, I'll be in see you first thing in the morning. I have to go see Liz Westgate anyways.
Okay.
Or at least I will come up and see you as soon as I'm done.
Yep. Go up to the 3rd floor, go in the clerk's office, let them know that you're here to see me. Okay.
Yes, sir.
All right. Thank you.
But I have more instructions. So Mr. LaFontaine, you gotta go see Miss Westgate in district court probation. You gotta go see Darren Coast. But you also have to go see my probation department, or the one that I with, okay? So I'm gonna put you in a breakout room real quick with Mr. Jones so I can get some information from you. He's from the Michigan Department of Corrections. He's gonna give you pretty much 2 instructions. One, you're gonna have to pick up a packet. You're gonna have to fill out the packet, you gotta drop it off. And then you're gonna have to come in and meet with one of the agents on the 3rd floor with the Michigan Department of Corrections. You must make those appointments. If you don't, I issue a bench warrant. When you meet with them, be truthful about your background, your addiction issues, your mental health issues, and the events that occurred here. They'll prepare a report. They'll send a copy of that to your attorney. You'll get an opportunity to review that with your attorney in advance. So you need to make contact with your attorney.
Okay.
And then we will see you back for sentencing on August 3rd at 8:15.
right.
Ms. Van Dusen, anything else you wanted to say?
No, Your Honor.
Okay.
Judge,
So I'm
we
going
did have the issue of restitution on that larceny in a building case. If you
Oh,
would like to
okay,
the
so,
restitution on that.
Mr. LaFontaine, one of the files that's being dismissed alleges that you committed larceny from a building, that you stole somebody's phone.
Yeah, I understand.
Did you take somebody's phone?
Did I take the phone? I never did take the phone on, ma'am. I did not take the phone out of possession of the Harley Busing's apartment at all.
I did. I did not hear what you just
I
said.
said, no, ma'am, I did not take the phone out of Harley Busing's apartment at all. I don't know when he came up when I took his phone, but I never did take his phone. When I was stopped and arrested, I had no cell phone on me, period. I had no cell phone. I didn't even have my cell phone on me at the time. My cell phone was left in Harley Busing's apartment itself.
Do you know this plea makes you responsible for restitution?
Yes,
of
that's
that
fine. I'll
phone?
take responsibility for it.
Okay.
And I think she got her cell phone back, Judge, so I don't necessarily think there is any restitution amounts, just that there is, that he would be responsible.
Okay. Got it. All right. All right. So I'm going to open up a breakout room, and Mr. LaFontaine, I'm going to put you and Mr. Jones in there.
Judge, he can just report when he sees Darren tomorrow morning. You can just pop over to our office and grab a packet.
Okay.
Okay.
So Mr. LaFontaine, tomorrow morning after you talk to Darren, go down the hall to the probation department and check in, all right?
All right. I'll see you tomorrow, Chris.
All right. Will you tell them I need Mr. Spence now?
Yep. So I'm on a PR bond starting tomorrow.
Yeah, you got a pair bond right now, so
All right, thank you, thank you.
you'll finish your 60 days tomorrow, so.
Okay.
Okay, so I just have Miss Spiegel. All right, Miss Underwood. This is Mr. Dagger. Rhonda, wait, I had Rhonda Underwood and she's gone again. Why'd she do that? Okay. In the matter of the people of the state of Michigan versus Cheryl Lynn McGrath, file number 22-21044FH. This pretrial, there was a stiffen order in the file that it was adjourned to 7/21. All right, so I don't need that one today. I'm sorry.
7/21.
7/21. Yep. 8:30.
Yeah, I think I'm done with your report.
I think so. I just need, Mr. Spence, who is your attorney?
Mrs. Underwood.
Okay. I think I lost Miss Underwood again, so hold on a minute. Mr. Dagger Margosian. Were we expecting Mr. Gilbert today?
He's in MDOC.
Right. But he was supposed to be written in, right?
Yes.
Let's see if I have a writ, because I don't have MDOC. Well, it doesn't look like there is a writ in the file. Miss Adams, did you have any email contact with MDOC regarding Mr. Gilbert?
I will check. I don't believe so.
Your Honor, the writ was done on June 8th, and our notes indicate that MDOC confirmed. This was the issue the last time as well. We were here, MDOC didn't show up with Mr. Gilbert, so I'm not sure what's going on, but there is a writ done.
All right, sorry, sometimes it doesn't make it to my file. It's you know, it might be across them, so. All right, so Mr. Dagger Margosian, it appears he's not here yet. It's only 10:11, so. There's Miss Underwood. All right, Miss Underwood, I have Mr. Spence. So this is in the matter of the people of the state of Michigan versus Michael Charles Spence, file number 23-21377FH. I have Attorney Mitchell Wood appearing on behalf of the Attorney General's office, and I have Rhonda Underwood appearing on behalf of Mr. Spence. This is the date and time set for arraignment in this matter. So, Ms. Underwood, how would you like to proceed with Mr. Spence? I think it's.
I believe this is arraignment, Your Honor.
No, let me see. I got a felony support. Oh, no, looks like it's first pretrial. I just have it. I don't know, something else. All right, so this is the date and time set for the first pretrial in this matter. Ms. Underwood, how would you like to proceed?
Your Honor, I've spoken to Mr. Wood, but could I just speak to him for a minute briefly?
Okay, Mr. Wood, I am going to open a breakout room.
Yeah, we spoke yesterday, but
Okay, I'm gonna open that breakout room.
thank you.
Yep. Right, Miss Underwood and Mr. Wood. So, Miss Underwood, what would you like to do now?
If I could just have a brief moment with my client.
Of course.
This may
So,
be-
Mr. Spence, I'm going to open up another breakout room for you and Miss Underwood. Go ahead and click on join, use the mouse. Yep, and click on join. Miss Underwood, are you back?
Yes, Your Honor.
I'll close that breakout room. We'll bring him back in 3 seconds. All right, we are back on the record in the matter of the people of the state of Michigan versus Michael Charles Spence. Ms. Underwood, how would you like to proceed today on behalf of Mr. Spence?
Your Honor, I've spoken with the Attorney General's office and I've spoken with Mr. Spence. The offer currently is that Mr. Spence can plead guilty as charged with one habitual, Your Honor, and the others would be dismissed. I've spoken to Mr. Spence about that, and he does not want to prolong this matter, Your Honor, and he is going to take that plea today.
All right, so with one sub, that makes it a 6-year felony, correct?
That's correct.
All right. Right, is that a correct recitation of the plea, Mr. Wood?
It is, Your Honor. I'm confident at some point, Ms. Underwood would have been conveyed the standard plea offer that the AG offers in these matters. In this case, he's got a $3,750 bond. If that amount was paid into the child support case, and then he would be allowed to be placed on a delayed sentence. During the delay, he could pay it down by half to get an attempt, pay it in full for a disorderly person non-support, but it doesn't sound like he's in a position to take advantage of that plea offer. So Ms. Brenner previously offered a single, the count of felony non-support and a habitual second. So that's correct.
Okay. All right, Mr. Spence, you want to raise your right hand for me?
Yes, ma'am.
Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth?
I do.
All right, can you state your full name for the record, please?
Michael Charles Spence.
All right, so Mr. Spence, you've heard the statement of your attorney and the prosecuting attorney. Is it your intention to plead guilty to count 1, child support failing to pay, with 1 habitual offense felony? So it would make the maximum penalty for this offense up to 6 years in prison. So is it your intention to plead guilty to that offense?
Yes, ma'am.
All right, are you satisfied with Ms. Underwood as your attorney and the advice that she has given you?
Yes.
All right, and sir, you understand that Mr. Wood stated that the standard plea had been offered to you in terms of if you're able to pay it down by half in 11 months, you would get an attempted, and if you paid it off in full, you would get a disorderly, but you don't feel that you'd be able to do that, is that correct?
Yes, ma'am.
Okay, and is this case currently charging, or is this arrears only, Mr. Wood?
It is currently charging, Your Honor. The child in this matter is 11 years old, and it's charging at $210 per month.
Okay, all right, so neither the prosecutor, the defendant, or anyone on the defendant's behalf has discussed a possible sentence with the court. Is that correct, Ms. Underwood?
It is, Your Honor.
And Mr. Wood?
That's correct.
All right, and is that correct as far as you're aware, Mr. Spence?
Yes, ma'am.
All right. If a guilty plea is accepted, there will be no trial. This means that you will be giving up rights you would have had at trial. I'm going to explain those rights to you now to make sure that you understand them. You have a right to a speedy public trial by jury. You may ask for a non-jury trial, and if the prosecutor and court agree, you can have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you are guilty, and you do not have to prove anything. You have the right to be present at trial and have witnesses against you appear at your trial and to ask those witnesses questions. You have the right to have the court order any witnesses you have for your defense to appear at the trial. You have the right to remain silent during your trial, not to have your silence used against you. However, you also have the right to testify at your trial if you want to testify. Do you understand that if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at trial? Do you understand that, Mr. Spence?
Yes, ma'am, I do.
Do you understand that any appeal from the conviction and sentence pursuant to the plea will be by application for leave to appeal and not by right? Do you understand that?
Yes.
If you are not a citizen of the United States of America, a conviction of a crime may result in deportation, exclusion from admission to the United States of America, or denial of naturalization. Do you have any questions about the rights that I've given to you?
No, ma'am.
All right, so how do you wish to plead to the charge that during the time period between July 1 of 2019 through August 31 of 2021 in the city of Adrian in the county of Monroe, that you did commit the offense of child support failure to pay? Guilty or not guilty?
Guilty, Your Honor.
Has anyone made any threats or promises to you to induce you to plead guilty to this charge?
No, ma'am.
Do you understand that if I accept this plea, you will be giving up any and all claims that your plea is given as a result of promises or threats that were not disclosed to the court on the record during this hearing, or that it was not your own choice to enter the plea? Do you understand that?
Yes, ma'am, I do.
Is the Attorney General or Defense Counsel aware of any promises or threats or inducements other than the plea bargain to induce the defendant to plead guilty? Ms. Underwood
No.
and Mr. Wood?
No, Your Honor.
All right. Has your attorney promised you any particular sentence or estimated what your sentence will be, Mr. Spence?
No, ma'am.
Is it your own choice to plead guilty?
Yes, ma'am.
All right. So, Mr. Spence, you have a minor child who is 11 years old, and you were ordered to pay child support on that case. Is that correct?
Yes, ma'am.
And you're supposed to pay, what did you say, Mr. Wood, 210?
That's the current monthly obligation.
Okay. All right. So, Mr. Spence, you were ordered to pay $210 a month in child support. Is that correct?
Yes, ma'am.
So during the time period between July 1 of 2019 through August 31 of 2021, did you pay your full $210 every single month?
No, ma'am, I didn't.
Okay. All right. Are you satisfied, Mr. Wood?
I am.
All right. Has the court complied with MCR 6.302 B, C, and D? Ms. Underwood?
It has.
And Mr. Wood?
Yes, Your Honor.
I accept the plea. It has been given understandably, voluntarily, and accurately. The defendant has full knowledge of his rights. He does have competent counsel. This court has made no agreement regarding the possibility of a plea or possible sentence in this case with the prosecutor, the defense attorney, the defendant, or anyone acting in the interest of either of them. I'm going to refer this matter to the probation department for a pre-sentence investigation. Ms. Underwood, are you available on August 3rd at 8:15?
That's fine, Your Honor.
All right. Mr. Spence, I forgot to ask one thing. Let's look here. Let's see. Spence something recent. 98. Still 2001. All right. How about this? So, sir, on May 21 of 2021, in the county of Hillsdale, were you convicted of attempted felony weapons carrying concealed?
When was this?
It says 2001, so like 22 years ago.
Yes.
In Hillsdale County, you had an carrying a concealed weapon attempted felony. Yes.
Yes, ma'am.
And would you agree that's a felony?
Yes, ma'am. Well, it's a high court misdemeanor.
Yeah, it still scores as a felony though. Okay. All right, Mr. Wood, are you satisfied on the supplement?
Thank you for that, Judge. Yes, I'm satisfied.
And I don't require the AG to be present for sentencing, but Mr. Wood, if you wanted to, are you available then August 3rd at 8:15?
I'm confident the AG will appear, and if we can appear via Zoom, that would be helpful.
Okay. So, Mr. Spence, well, Ms. Underwood, what were you gonna say?
May I be heard as to the issue of bond in this matter, Your Honor?
Sure.
Your Honor, prior to Mr. Spence being arrested, he had been sporadically making payments. I think Mr. Spence has been employed, and I know we've discussed that he is willing and able to get out and make these payments, Your Honor. I think that in view of the plea here today and the sentencing date, I think the smartest thing we could do is let Mr. Spence out and get him started making payments. And that way we're much more informed on August 3rd when we come back for sentencing. And he's had a chance to prove to us he can do this, Your Honor. I know he discussed that for the immediate term. I know Martin Rea is hiring. I think Mr. Spence, if he got out, could have a job by tomorrow and be making payments, Your Honor. And we would, I think the last payment he made was only in like March or something, Your Honor. So he does sporadically make payments. And I think he would welcome the opportunity to prove to this court he can get right with this.
Mr. Wood, would you like to weigh in?
Judge, he actually made 2 payments in May via wage assignment. He paid $38 and $73, and he had a wage assignment, nothing in April, which is, I don't fully understand how he gets these short wage assignment situations, but he did pay in March, didn't pay in January, February, but he paid going back, he was paying in, well, that's it. Yeah, then he hadn't paid since 21. But Ms. Underwood brought this topic up when we were in the breakout, and I, told her, and she certainly understands. She's done a lot of these that it's the AG's policy, not to stipulate to a PR bond. I mean, again, the whole idea here is to get the money flowing, and again, he has, as Ms. Underwood said, made some sporadic payments in the past. So I would, I would leave it up to your discretion, Judge. Obviously, if he doesn't get with the program, then it's just going to get worse here. I mean, he's got 6 years of exposure now. So that's my comments, Your Honor.
Okay. So, Mr. Spence, unfortunately, I'm going to guess you probably lost your employment when you became incarcerated. So I am going to release you on a PR bond, Mr. Spence. By sentencing, I want you to be employed, okay? Martin Rea is always hiring, and they have like bus transport from Adrian and Jackson. So there's always opportunities out there. You have to, and this going forward, you need to understand, you need to pay the 210 that is currently accruing every month, but you have to pay on your arrearage. And I mean, that's a lot of money, but you need to pay at least $310 a month, okay? Yes. And that's going to continue throughout your term of probation. So I am going to give you a PR bond and order that you pay $310 a month. Now, until sentencing, which will be August 3rd at 8:15 in the morning. And Mr. Spence, I want you to come to the courthouse in person on August 3rd at 8:15.
Yes, ma'am.
But listen to me, if you have a job and you would lose your job by coming at 8:15 in the morning, you call Miss Underwood, and Miss Underwood will set sentencing for a time that wouldn't interfere with your job. Do you understand?
Yes, ma'am.
Because I'm much more concerned about getting child support. So if you're working and you can't take it off, call Miss Underwood and we'll adjourn it. We'll do something to accommodate you. So you're going to get released from the jail today. There's nothing else holding you, correct?
Yes, ma'am. No.
Okay. Tomorrow morning at 8 a.m., I need you to come to the 3rd floor of the courthouse. And across from my courtroom is the probation department, 3rd floor probation department, okay?
Yes, ma'am.
And I need you to check in. They're gonna set up a time for you to meet with them and give you a packet to fill out. It's very important that you make both of those appointments. And when you meet with them, be truthful about your background, be truthful about the events that occurred, and they'll prepare a report. That report will be provided to Miss Underwood. Miss Underwood will meet with you in advance and she'll review that with you. And then I need you to appear on August 3rd at 8:15. And like I said, if it's going to impact your job or cause a problem, talk to Miss Underwood. We can do it via Zoom or we can adjourn it, okay?
Yes, ma'am.
Do you have any other child support cases?
No.
Good. All right, so we'll see you back on August 3rd. Tomorrow morning, I need you to head to the to circuit court probation, okay?
Yes, ma'am, at 8:30, correct?
Well, the courthouse opens at 8, so get here between 8 and 10, all right?
Yes, ma'am.
All right, thank you, Mr. Spence. Thank you, Mr. Wood and Ms. Underwood.
Thank you, Judge. Do we also have Brian Goodyear?
Your Honor.
With Ms. Underwood?
Thank you. Mr. Goodyear waived arraignment. Let me look here. They waived arraignment.
All right,
Okay.
I'll let the AG know. Thank you very much.
Okay.
Thank you, Ms. Underwood. Thank you, Judge.
Thank you. Okay, Ms. Underwood, Jason Wright, file number. Mr. Spence, I'm all set. Will you let them know I need Miss Spiegel?
Ms. Gill?
Miss Spiegel.
Spiegel, yes, ma'am. Yes, ma'am.
All right, thank you. All right, Ms. Gilbert. All right,
He
so
heard the same
Miss,
thing last night.
what?
I was laughing because I think I went from him to Brianna last night, so.
Okay. All right, this is in the matter of the people of the state of Michigan versus Jason Scott Wright, file number 22-21032FH. I do have a proof of service and a notice of hearing that my staff prepared on May 10th of 2023, setting it over to today for a pretrial, and he was given personal service according to this. But I also have a note that he failed to appear on April 26th. So Ms. Underwood, he's part of the economic diversion program. Do we have any information about that?
Well, Mr. Wright was kind of confused. I talked to Mr. Went this morning. He paid a bond that he thought should have taken care of his diversion, but that's not how it works. You have to take care of the case, or you have to pay the diversion, and then when the case is resolved, you get your bond back. But I have not been able to contact Mr. Wright. So I
can apply. I think I can order that his bond be applied. Can I? Do I have a prosecutor? Fleming, Ms. Meir, Mr. Fleming. Can I order that his bond be applied to restitution?
I believe so. According to the Crime Victims' Rights, I would believe so, Judge. I've never came across that, though, to be honest with you.
Anybody want to weigh in on that?
I know Miss Meir just stepped away. Let me check. I'll be right back, Judge.
Because I have a note in here that he posted bond in the exact amount of restitution.
Okay, let me check. I think he may have to sign it over as far as that goes, to release the bond to apply to that. But let me check.
All right, Ms. Underwood, do you need a moment to speak with Ms. Spiegel?
Your Honor, I spoke with Ms. Spiegel last night, and I spoke with Ms. Teskey today, and I think Ms. Spiegel is set to be sentenced in district court, and I believe it's the 17th of July. And we would ask for a adjournment till right after that, no longer, Your Honor.
Well, Miss Adams, do I have anything available on July 18th, early in the morning, like at 8? Or
I will not be here to do paperwork, but you could, yes.
what about the 19th?
I'm gone.
20th?
I'm gone that week.
You're gone the whole week?
Yes, ma'am.
Am I gone that week?
No.
Oh, that's gonna be messy, isn't it? All right, well, I don't know what to tell you. How about July 18th? Am I here that day, Miss Adams? Do I have an 8 o'clock available?
You are here. You do have an 8 o'clock judgment and motion. And 8:15 paternities.
All right, Miss Underwood, how about July 18th at 8 o'clock?
I will be here right at 8, Your Honor.
All right, you may have to do the paperwork for Miss Adams too, because I don't know how to do it. All right. I'm just kidding. All right, so Miss Spiegel, we'll see you back on July 18th at 8 o'clock in the morning, all right?
All right, thank you. Have a nice day.
You
So
too,
if there
thank
was a
you.
If there was a conviction that bond amount that was done by the,
Hold on, Mr. Fleming, hold on one second. Go ahead, say it again.
if there was a conviction, that bond amount that was bonded by the defendant himself can be applied towards restitution. If it was, you know, paid for by somebody else, they would have to sign off on it being submitted for restitution.
All right, so who signed his bond? I have a bond, let's see, did I issue a benchmark form? Let me see here. So motion affidavit and bench warrant for failure to appear. And person building. I show he has a PR bond. Like Becky, I'm showing. Oh, I issued a bench warrant with a 40,000 warrant. And a 5,000 cash surety down in district court. Are we sure he paid 110 or 810?
Judge, if there was a bench warrant after he posted bond, it would have been forfeited.
But wouldn't the paperwork from this bond be in the file?
It should be, yeah.
But you can look at the file. Usually Miss Escott has it posted, or like usually there's a bond sheet. I don't show that he got it posted. Hold on, we're checking. So Miss Underwood, I know I have a note in there, but it looks like he held a prelim and they gave him a PR bond.
I'm sorry?
I don't show, I'm not finding paperwork where you ever posted $810. I show that at the prelim, he got a PR bond.
Well, we'll have to find out what happened, Your Honor.
Well, he keeps not appearing, so I'm gonna issue a bench warrant for him, and if you find him, you'll let me know.
Can we have a 48-hour grace period on that, Your Honor?
I'm required to give you 48 hours before I sign it.
Thank you.
So I'm gonna issue a bench warrant, I'll set bond in the amount of $810.
Thank you.
Right. Is that on Mr. Wright?
Yes.
Okay.
Okay. All right, so we are back. I'm gonna remove the jail room. Miss Underwood, I don't think you have
Anything left?
anything left. Thank you.
Thank you.
Thank you. Get the jail room out of there. Alright. So, Mr. Gilbert, can you hear me?
Yeah.
Okay, so this is in the matter of the people of the state of Michigan versus Adam Joel Gilbert, file number 2022-21063 FC. I have Jennifer Bruggeman appearing on behalf of the people, and I have Michael Dagger Margosian appearing on behalf of Mr. Gilbert. Mr. Gilbert is joining us from the Michigan Department of Corrections. Today is the date and time scheduled for a resentencing. I do have defendant's motion to deny resentencing, as well as the people, well, I have the people's answer to the defendant's motion denying resentencing and the motion to deny resentencing that was filed by Mr. Dagger-Margosian. We also have a transcript taken at the time of the plea, as well as at the time of sentencing. So, Mr. Dagger-Margosian, I guess we can start with your motion.
That's fine, Your Honor. May I just have a quick moment with Mr. Gilbert before we start?
Well, you faded out at the end. Who?
With Mr. Gilbert, a brief breakout room, please.
Okay, so Mr. Gilbert, let me pop you in a breakout room with Mr. Dagger-Margosian. All right, Mr. Dagger-Margosian, have you had enough time to speak to your client?
Yes, Your Honor, thank you.
Close the breakout room. Ms. Smear and Mr. Fleming, I'm done with my criminal docket except for this, unless you're just hanging out to watch this. I don't show any more files.
I was missing Emily Smith, but I probably just missed it.
I think Emily Smith failed to appear. They issued a bench warrant and set bond at 50,000 cash.
Okay, thank you. I am gonna stand and watch this though. Thank you.
All right. All right. So, Mr. Dagger-Margosian, are you ready to proceed? Yeah. Okay. All right. So, Mr. Dagger-Margosian, I guess we can start with your motion to deny resentencing.
Thank you, Your Honor. I'll just highlight a few relevant factors. Again, this is a motion to deny a resentencing in Mr. Gilbert. The pertinent facts, October 26th of last year, Mr. Gilbert pled guilty to the second. He was subsequently sentenced on February 9th of this year. After that sentencing date, this court received a letter from MDOC about a month after the February 9th date, and that alerted this court to a potential sentencing issue, specifically that lifetime electric monitoring had not been ordered, was not on the judgment of sentence, was not in the PSI. And so again, MDOC alerted this court to that potential issue. In reviewing in preparation for this hearing, in reviewing the PSI, I didn't see mention of a lifetime electric monitoring. In reviewing the sentence, I saw that the box for lifetime electric monitoring was not checked. And in reviewing the transcripts, I didn't see mention of lifetime electric monitoring. I did see mention of SORA, obviously, but that's different than lifetime electric monitoring. Namely, it's controlled by two separate groups of statute. Lifetime electric monitoring being 750-520N, SORA being 28.719 et sec. So moving on to the law, Your Honor, obviously a sentencing court cannot modify a valid sentence. That's People v. Wybrecht, 222 Mishap 160. The sentencing court lacks authority to order resentencing. The original sentence is valid, and this court neglecting to sentence Mr. Gilbert to lifetime electronic monitoring does not deem that sentence invalid. So therefore, I believe that the sentence must remain untouched. Furthermore, a court cannot order or conduct a resentencing on its own unless for clerical correction, and that's this is really the case at heart, which is People v. Comer, 500 Miss 278, for a resentencing to occur for a substantive change, which certainly adding lifetime electric monitoring would be, and that is outlined in Worthington, which I'll get to in a second. The substantive change, it has to be requested by a party within the allowed time frame. This is governed by MCR 6.429 and 6.435. Your Honor, I don't think that this court has to look any further than People v. Comer. It's almost identical to the situation that we have here. In that case, the trial court corrected an invalid sentence that had been imposed after sentencing. The court changed the sentence to conform to statutory requirements, which again is what would be happening here, checking the box for lifetime electric monitoring. The sentencing court believed that the correction was clerical. It thought the amendment was correctly done. When Comer was appealed up to Michigan Court of Appeals and then subsequently to Michigan Supreme Court, it was held that that change was substantive, and amending the judgment of sentence on the court's own accord was improper, and so the Michigan Supreme Court held that the remedy for that was to return the sentence to the original sentence. So moving on, I'll wrap up in a second, but moving on, People v. Worthington, a year after Comer, held essentially the same thing. The important language is that, quote, in Comer, we held that correcting an invalid sentence by adding a statutorily mandated term is a substantive correction, and that the court may make the change on its own only before the judgment is entered. And then lastly, in People v. Murray, which is a published case that is attached to the defendant's motion and brief, it again held the same. And this, importantly, Murray was after the amendments to MCR's 6.429, 6.435. So, and then to wrap up, the DC notifying this court of any potential issue really is improper. I mean, they're not a legal representative, they're not a party in the matter, and this language was conveyed in People v. Holder 483 Mich 168. So with all of that being said, Your Honor, I think it would be impermissible for this court to amend the sentence that was originally issued on 2/9 of this year, and I would ask the court to deny any modification to the sentence.
Great. Thank you, Mr. Dagenberg. Ms. Brugman.
Thank you, Your Honor. First, few procedural things. Can we have Mr. Gilbert waive his in-person appearance as well as waive any updated PSI?
I have no objection to that.
All right. So, Mr. Gilbert, you have no objection appearing via Zoom today, is that correct?
Correct.
All right, and do you waive having an updated pre-sentence report today?
Correct.
Okay. Mr. Jones, I do not have the PSI, by the way. I don't think I do. Maybe I do. No, I don't. I do. Never mind, I found it. All right. It's tucked away at the back. All right, Ms. Brugman, you may proceed.
All right, thank you, Your Honor. As I laid out my answer, I feel this is a pretty straight, cut and dry issue. MCR 6.429 after Comer was amended, and it allows this court to sua sponte, amend an invalid sentence within 6 months of the original date of sentencing. We're within that time frame. And in my opinion, and MDOC's opinion, and really, I believe this court's opinion, this sentence is invalid because Mr. Gilbert was convicted of CSC second under MCL 750.52C 520C2B, which requires lifetime electronic monitoring. It is a requirement under that statute. So and on top of that, this court actually did sentence Mr. Gilbert to lifetime electronic monitoring. That is clear in the sentencing transcript. This is not a situation where the court did not sentence Mr. Gilbert to lifetime electronic monitoring and is now amending the judgment of sentence. Although even in that situation, I believe that this court would still be able to resentence Mr. Gilbert. This court did sentence him to lifetime electronic monitoring at the time of sentencing, but just simply failed to checkmark a box on the judgment of sentence. To me, that's a clerical error. And I indicated in my motion as such, or in my answer as such, but even if this is viewed as a substantive error, this court is certainly entitled to resentence Mr. Gilbert to what it is required to do under the statute. And so I don't believe any of the case law that Mr. Dagger-Margosian is citing is on point or still valid in light of the amendment to MCR 6.429 sub A. And so at this point, I would ask the court to resentence Mr. Gilbert to the same provisions basically they did in the initial sentencing, but simply the judgment of sentence needs to include the lifetime electronic monitoring. I don't believe that the victim is here today. I only wanted to have the court double check their waiting room or the courtroom. I wasn't expecting that, but I just wanted to make sure. But other than that, Your Honor, I would ask the court to deny the motion and resentence Mr. Gilbert to the same terms that they did on the original sentencing. Thank you.
Mr. Dagger-Margosian.
Your Honor, in response, as to a sentence pre and post amendments of the sentencing court rules, again, People v. Murray reiterates that Worthington and Comer are still good. So I would say that. So then the next issue is was this sentence invalid? And I would say no, it was not invalid. The fact that a court omits something, even if it's mandated by statute, does not necessarily make that sentence invalid. There's many times where a court will omit consecutive versus concurrent or credit or anything where it's mandated by law, but if it's omitted, that doesn't necessarily make the sentence invalid. And because, so in other words, it was a valid sentence, and again, this court cannot amend a valid sentence. And so again, lastly, Ms. Bergman indicated that this court had sentenced Mr. Gilbert to lifetime electric monitoring in either the plea and or sentencing colloquy. I didn't see that. Again, there was a requirement for SORA. I certainly agree with that, but I didn't see an order requiring lifetime electric monitoring. And SORA and LEM are not the same thing. And so because of that omission, unless I just missed it, but I reviewed both transcripts. Because of that omission, I would again indicate that this sentence was valid and cannot be changed.
Okay. Thank you. So the court rule cited by defendant is MCR 6.435, which indicates when and how the trial court may correct an error in a judgment of sentence. A, clerical mistakes. Clerical mistakes in judgments, orders, or other parts of the record and errors arising from oversight or omission may be corrected by the court at any time on its own initiative or on a motion of a party and after notice if the court orders it. B, substantive mistakes after giving the parties an opportunity to be heard and provided it has not yet entered judgment in the case, the court may reconsider and modify, correct, or rescind any order it concludes was erroneous. However, in this case, the applicable rule is MCR 6.429A, which permits the court to correct an invalid sentence on its own initiative after giving the parties an opportunity to be heard or on motion by either party. Any correction of an invalid sentence must occur within 6 months of the entry of judgment of conviction and sentence. While defendant contends that the court has imposed a valid sentence, failing to include a mandatory provision for lifetime electronic monitoring renders a sentence invalid. The very case on which the defendant relies specifically addresses this precise scenario. In Comer, the defendant was not sentenced to have a lifetime electronic monitoring, and the error was brought to the attention by the court by an MDOC letter, the exact circumstances which occurred here. The Comer court determined that the trial court's failure to include this mandatory provision rendered the sentence invalid. The Comer court did rule that the trial court could not correct an invalid sentence on its own initiative after the entry of the judgment. It could only do so on motion of a party. However, the court rules have been amended since that time as a direct result of the Comer decision, specifically to empower the trial court to correct an invalid sentence sua sponte. In this case, the sentence is invalid for failing to include the lifetime electronic monitoring provision, triggering the authority of MCR 6.429A. The court is giving the parties an opportunity, obviously, to be heard at resentencing. The original judgment of sentence was issued on February 9th of 2023, so this hearing is within 6 months. Accordingly, the court has the authority to issue the amended judgment of sentence to include the lifetime electronic monitoring provision. Therefore, the defendant's motion to deny resentencing should be denied. I would also make note that at the time of the plea, on page 6 of the transcript, when advising the defendant of his rights, I did ask, do you understand that by entering a plea to this offense, you will be required to register for lifetime under the Michigan Sex Offender Registration Act? The defendant responded, yes. And I said, and I think that would also include, that would also include lifetime electronic monitoring. So that would be like a tether. Is that correct, Mr. Dagger-Margosian? Mr. Dagger-Margosian did acknowledge that. So at the time of the entry of the plea, I just felt it was important to add that Mr. Gilbert was at that time made aware of that requirement. So procedurally, do I, Ms. Breggerman and Mr. Dagger-Margosian, do we resentence or do we simply issue an amended judgment of sentence? Ms. Breggerman?
Your Honor, because this is set for resentencing, I think if it was just a clerical error, I would think that you could just amend the judgment of sentence, but just from an appellate standpoint, I would ask the court to resentence.
That's fine. All right. So Mr. Dagger-Margosian, at the time we sentenced him, you had had an opportunity to review the pre-sentence report with your client. Is that correct? So Mr. Dagger-Margosian, we're not getting audio on you, and that's unusual because usually we don't have problems with you. Like we're getting, say it again.
Can you hear me now? I don't think there's any obstruction. So how about now?
Yeah, we can hear you now. Maybe it was just the way you were facing. All right, so I know that you had an opportunity to review the pre-sentence report with Mr. Gilbert. Do you need a moment to speak with him?
No, Your Honor.
All right, so Mr. Gilbert, when we were originally here for sentencing, you had an opportunity to read and review the pre-sentence report. Is that correct, Mr. Gilbert?
Yes.
And you had an opportunity at that time to discuss the pre-sentence report with Mr. Dagger-Margosian. Is that correct?
Yes.
Now, Mr. Gilbert, this is the exact same pre-sentence report that we're using today that you discussed with Mr. Dagger-Margosian. Do you understand that?
Yes.
All right. Mr. Dagger-Margosian, do you wish to explain or challenge the accuracy or relevancy of any information in the pre-sentence report?
No, Your Honor, I think there would just have to be an updated amount of credit, but other than that, I think everything would be the same.
Judge, that'll be 322 days.
322. Okay. Other than that, Mr. Dagger-Margosian, anything you wish to explain or challenge?
No, Your Honor, thank you.
All right. Does the pre-sentence report disclose any prior convictions in which there exists any known constitutional defect?
None known at this time, Your Honor.
And his guidelines. All right, let's see, guidelines. Yep, okay. The probation department has computed the minimum sentencing guidelines to be 19 to 38 months. Do you agree with that, Mr. Dagger-Margosian?
I don't have any challenges at this time, Your Honor.
Okay, before the court passes sentence, Ms. Bregman, is there anything you'd like to say on behalf of the people?
Your Honor, I would just reiterate everything that was said at the original sentencing. I know there was some argument at that time about guidelines, and I think those were all resolved. And I believe this court previously sentenced him to 38 to 180 months, and I would ask for the same along with lifetime electronic monitoring, SORA, and all the other provisions that with regard to the victim and no contact, and otherwise leave it in the court's discretion.
All right, Mr. Dagger-Margosian, anything you'd like to say on behalf of Mr. Gilbert? Mr. Gilbert, is there anything you'd like to say?
No.
Okay. All right, so in determining the appropriate sentence in this case, the court has considered the seriousness of the offense, your history, the principle of proportionality, the statutory penalty, the cost of confinement, the sentencing guidelines, the report and recommendation of the probation department, as well as what has been set upon the record at this hearing. The criteria and reasons for the sentence are the nature and gravity of the offense, the discipline appropriate to its commission, deterrence against repetition by you and by others, the potential for reformation, vindication for the law, and the protection of society. It is the sentence of the court. Hold on. I'm gonna do this. That you will serve 38 to 180 months with the Michigan Department of Corrections. I will give you credit for 322 days already served. You'll pay $130 crime victim rights fee, $68 at state costs. You are to have no contact with the individual with the initials of AG or DG. You are to have no contact with minor children 17 years or younger. You must comply with the Michigan Sex Offender Registration Act requirements in this case, and you will remain active on the sex offender registry for life, as well as you are required to have a lifetime electronic monitoring. Anything else, Mr. Jones, with regard to SORA?
No, Judge, that's it.
All right, now, that's what you said last time, according to the transcript. I was just laughing word for word. All right, so Mr. Gilbert, you do have the right to appeal the sentence We're gonna send to you 3 copies of your notice of right to appellate review. One is for your records. If you wish to appeal the sentence, you would fill out the information on the form and mail it to the address listed on the form within 42 days. So they're gonna have you initial and date 1 copy, and they'll send that back to us for a file just to acknowledge you received the paperwork. The other 2 are for you. If you wish to appeal the sentence, you would fill out information on the form and mail it to the address listed on the form within 42 days. And I don't think we've missed anything else. Is that right, Ms. Bruggeman?
I think we're good. Thank you.
All right, Mr. Dagger-Margosian.
I think that's complete. Thank you, Your Honor.
All right. So, Mr. Gilbert, thank you for your patience, and I wish you the best of luck. Thank you.